Press the bell icon on YouTube and don't miss another update.
Welcome to ThePrint. We're sitting here with Justice Kurian Joseph. He retired as the third senior most judge of the Supreme Court on Thursday. Welcome, sir.
Thank you.
So far, it's been very hectic and busy for you, at least the past 5.5 years that you've been a judge at the Supreme Court.
Certainly.
So come Monday, what is your routine going to be?
Even in the High Court also, as a judge in Kerala for 10 years almost, and then Himachal for 3 years, and then in Supreme Court 5 years and 8 months, I kept myself pretty busy because I had about 66,000 cases I disposed of in Kerala.
Yes, sir.
More than 15,000 in Himachal, more than 8,000 cases in Supreme Court.
And you authored around 840 judgments.
No, it's a complete judgment which is authored by me and is more than 800, and together we have crossed 1,000.
That's fabulous. So come Monday, sir, what is your new routine going to be like?
Yeah, I'm going to be in the field of law only.
Yes, sir.
I don't intend to take any government assignment.
Right, sir.
I don't want to go for any such programs also.
Okay.
But I have a field of arbitration and mediation.
Mm-hmm.
And I have my own plan of a new concept to be introduced. That is a mediated arbitration.
Mm-hmm.
And also conciliated mediation.
Okay.
So just club this both ideas together. The reason is, see, the arbitrations now end up first before challenging the original code, then the appellate court. Settlements also, people are not happy, they keep on challenging it.
Mm-hmm.
So instead, if you can find a midway, as to you can have both parties agree to the award that you pass and convince them that this is what is just and what is correct.
Yes, right, sir.
That will be the end of it. Therefore, both will be happy. They don't have to pursue the litigation.
Was this the approach you also used in the Supreme Court while hearing matrimonial matters and family matters?
Yes, not only matrimonial, of course, certainly all this method are used.
Right.
But in commercial matters, even in a case relating to dispute on intellectual property also,
Right, sir.
I got settled through mediation.
Okay. So that's wonderful. So also, like you said, you've been a judge for so many years, especially a Supreme Court judge also for 5.5 years now. What do you think has been your biggest mark as well as the biggest mark on you? Your experience, what's the one thing that you take away with?
If you ask me what I could do in Supreme Court.
And what it did for you?
Yeah. I showed to people that it is also a court for common man.
Right, sir.
So it can also change the lives of people. It's not the big judgments with so much of international jurisprudence that you contribute by the Supreme Court. But even a small judgment where a person gets a just compensation in a motor actions case, a person gets a right and appropriate compensation in a land acquisition case.
Right, sir.
A class 4 employee working for over 20 years or 25 years gets a regular post. And a person working for a person undergoing the process of disciplinary proceedings and just not getting a finality to the procedure, etc. So all these areas where it's all cases where the people I could see a person, the face of a human person, person crying for justice. For him, it is not the constitutional interpretation of his rights that is important. For him, it is a question of justice.
Right.
So that is one message I could give to. Okay. And I also gave a message to people that there is no point in keeping on fighting like this. I could find people who have been fighting for decades.
Right.
Second generation, third generation. One case which we dealt with the property dispute on partition. It was the fourth generation which were fighting. So I asked them, what's the purpose? The first generation could not even see the end of a litigation. Second generation could not see it. Third generation could not see it. And do you want to continue this, or you want to enjoy the fruits of your own property without any litigation and purchase peace? And I could fairly convince them.
Right, sir.
On principle that it is time for us now to say goodbye to litigation. And it is time for us to say part with the lawyers also, because the money they have spent in litigation, I'm quite sure, would have been much more than the property they would be getting.
That's true.
I could convince them.
Right.
And then then on principle, once they agree that there should be an end of litigation, then it is very easy. Then because the communication is through, then it's only a question of sitting together and working on the modalities. I could do that. So that was what I did. And in matrimonial matters, I always used to tell the people, because you are traveled up to Supreme Court now.
Right.
See, there's no point in fighting like this from the family court to the High Court and Supreme Court. There's only two things. Either you mend your relationship or you end your relationship. If you want to mend it, please bend a little. If you find and if you're quite convinced that you cannot bend it at all and mend it, better end it and part as friends. So all those people who have parted ways in my court, they're gone as friends. That way I was quite happy, so that there is no acrimony thereafter and there's no litigations thereafter.
Right.
So, and you asked me what I would wish people to think about me.
Yes.
Yes. Same thing which I said.
Right.
A person who could see the human face of justice.
Right. So your religious views are very well known. You've been very open about them. You've been very public about them. Has that in some way shaped or molded your thought process while you deliver a judgment? Because there are issues like marriage, death penalty, abortion. Has there been any conflict if you've perhaps had to give a decision which is against your religious views?
I never faced any conflict.
Okay.
I've taken an oath.
Okay.
That I am discharged by duties according to, in the name of God, to the best of my ability, knowledge and belief.
Right,
And that it will be done without fear or favor, affection or ill will. Right. And that I will uphold the constitution and the laws.
Right,
My oath was not to uphold my faith. As a judge, my oath was to uphold the constitution and the laws. So there's no question of any conflict. My faith is my personal issue.
Right.
Well, as a judge, what I will be interpreting is the constitution and the laws made thereunder. So there was no occasion for a conflict.
Right.
But if you ask me if my faith has influenced me, yes, on the concept of justice, it has influenced me because I feel justice is truth and truth is God.
True, sir. So I think one of the most famous examples of death penalty cases that has come before you was the Yaqub Menon case, and I think you gave a split verdict with Justice Anil Dave, hence it went to a larger bench.
Yeah.
So I think that's where it all began.
Yeah. Reason is not that. If you remember, see, that was a case. I was part of a review bench. In that review bench, Justice Anil Dave was there, Justice Chelameswar was there, and I also was there.
Right, sir.
That was a review against death penalty.
Right, sir.
Well, it was a unanimous decision to dismiss it. Because on review, what we were examining is the contestants now taken by the petitioner for reviewing the judgment had already been taken. We found that all those contestants had been taken. So there was no reason for us to revisit the judgment in exercise of our review power. But sometimes, looking back, I feel the approach would have been a little different in the sense. In death penalty review, question is not whether the case has been, arguments have been properly addressed. It would have been a different way. But forget about that. The difference of opinion came thereafter. Even a death row convict is entitled to, according to our constitution,
Yes, sir. Absolutely.
that his life can be taken. That's the beauty of our constitution, Article 21. That if you want to interfere with the life and liberty of a person, it can be done only in accordance with the procedure established by law.
Right, sir.
So, in Yaqub Menon, the question was whether the procedure established by law, namely his consideration of a curative petition, was it done in terms of the procedure prescribed in the Supreme Court rules?
Right, sir.
I raised the question, it was not. Because the curative petition was not considered by a bench which should have considered in accordance with rules, because the people who were part of the consideration should be part of the curative bench. They were not there.
Okay.
One was me, one was Justice Chelameswar.
Right, sir.
So without us, the curative petition was considered.
Right.
Therefore, he did not get justice in considering his curative petition. Well, this question which I said, that the approach in death penalty review should not be ordinarily approach in review, was the question raised in that curative petition. Probably if we were there, the approach in curative petition would have been different. That was why I disagreed with Justice Dave, and I said that Supreme Court is not powerless and law is not helpless.
Right, sir. So this past 1 year has been extremely active for the Supreme Court for all the wrong reasons. Starting, of course, with the press conference which you were part of along with the 3 other judges on January 12th. Since then, as you said the other day also, the crisis is not completely over, but there has been a change. What, according to you, has been the biggest change?
So a lot of transparency has come in position.
Okay.
And number 2, there is an attempt thereafter to introduce systems and practices in the place of an individual taking a decision.
Okay. So now you're saying it's a more collective decision as opposed to an individual taking a decision.
I would like to call it as an institutionalized approach.
Okay. So before you took the press conference, I recall you had also said that you had sought, you along with the other judges, had asked the then Chief Justice Dipak Misra for full court meetings several times. And because it never happened, that's why you took the step of holding the press conference. Did you perhaps approach any other judges apart from the 4 of you to participate in this press conference, or was it a decision that it was just the 4 of you who wanted to?
It's just the 4 of us.
Okay.
Because all the earlier attempts were taken only by 4 of us.
Okay.
Requests were made, attempts were made, because the 4 of us, along with the Chief Justice, came into a category called the Larger Collegium.
Yes, sir.
So since 4 of us only were involved in the process of bringing to the notice of the Chief Justice as to steps to be taken and the path of what you call corrective steps to be taken, etc., etc. Well, at that stage we did not involve any other judge. We were only 4 of us were there.
After the press conference happened, okay, not to take any names, but were there any brother or sister judges who came up to you and said, I wish you had told us, we would also like to participate with you?
There were individual, yes, there were individual such observations.
That they would also perhaps like to have come at that time and supported you or participated in the press conference with you?
Yes, yes.
Ballpark number? 1, 2, 5?
No, I don't want to make the number, but there was a reaction like that. There was another reaction that you did not tell us, you did not, that things were not going correct also. So both reactions were there.
Right, sir. So in the immediate aftermath of the press conference, speaking to a lot of people, former judges, current judges, as well as senior advocates alike, including members of the bar, junior members of the bar, there was this strong reaction, or there was a strong opinion and observation that perhaps you should not have come out and spoken to the nation like you did. The institution and the integrity of the Supreme Court should have remained intact, and perhaps you should have made more of an attempt to try and sort it out within the walls. You shouldn't have come public. What is your opinion on that? I mean, obviously you did come out, so you have stuck by your word, but that was quite a strong...
This observation is perhaps because they did not know, or they do not know what we have done earlier.
Right.
We tried to find a solution institutionally, internally, and we tried all our methods to get things in the proper perspective.
Right, sir.
Since all our attempts failed, finally, as I used to say, the barking dog barked and barked and barked.
Yes, sir.
But finally it had to bite to protect the interests of his master.
So just a few more questions.
There was another reason also.
Yes, sir.
That is a reason which I want to ask the media also. My firm conviction is media is also a watchdog.
Yes, sir.
Well, why the judges were forced to come and tell the people? Because the media also was not doing their role.
Okay.
Had the media been alert, they could have better brought to the notice of the nation these things.
Right, sir.
It's not as if media did not know. Media also were somehow in the know of things.
Right, sir.
So they also failed.
Okay.
So we thought, as one of the watchdogs, we should also tell the other watchdog also, look, this is the time that you also have to little more vigilant, little stronger, and
Sure, point noted, sir. You've said and you've maintained that again, the friction between the government and the judiciary has also been escalating since the past couple of years. It's always been there. It's not that it's just current or it's just because of this present government. It's always been there. But perhaps the escalation against and with the judiciary has been a bit more obvious in the past few years. And even though you've maintained that, at least in your case, the government has not pressured you on the judicial side, but there is maybe some interference on the administrative side.
All right.
Now, let me finish, sir. We've spoken about this earlier as well. The last collegium decision of elevating 4 new judges to the Supreme Court. It was perhaps seen as it was complicit with the government because it never has a government passed off or signed off on collegium decisions so quickly. I think what we recall, it was the decision was given on a day, and the very same evening the medicals of the judges were being done. So within 24 hours to 48 hours it was signed off. So, and also 2 of the names of the 4 names have let's just say they've been mired in controversies individually. So anything on that front, sir? Perhaps maybe that the government pressed for these names and that's why it was signed off so quickly?
Let's forget about the names. When did the friction start? Friction started when the executive started interfering with the independence of judiciary.
Right, sir.
Right. What was that interference? That interference was in the matter of appointment of judges.
Absolutely.
Right. It was not an interference otherwise into somebody talking to the judge or influencing a judge in the judgment, etc. It's not like that. It was a perception. And we were also quite sure that there is an interference. So that was the reason why we had to come out. So it's a question, this friction, it was not there earlier, as you said, because there was no interference. The moment the interference started, the friction started.
Right.
That is the reason. That's the background.
Right.
Now with regard to the appointments, see, the appointments were made as far as collegium decision is concerned, it was unanimous. If the government could do a decision in 2 days or 3 days or even 1 day, that means they can do.
Yes.
And if they want to delay it, they can delay it also.
Yes, sir.
You have seen appointments being delayed for how many months and years also.
Months and years also.
That means that is also interference.
Right, sir.
See, if there is some disagreement, as per the law now existing, they should revert back to the Supreme Court.
Right.
They cannot hold it back.
Right.
Holding back is an interference.
Right, sir.
And selective appointment is another interference.
Right, sir.
So these are the reasons for the friction, obvious reasons for the friction.
Right, sir. So we're still not going to talk about the last 4 appointments.
No, that I said latter part I learned because they are my brothers now.
Right, sir. Okay, moving on. Last question and then I think we should wrap up.
I said not because they are brothers. As I told you, that was a unanimous decision by the collegium.
Sure.
There was no other perspective, there was no other objection with regard to their appointment.
All right, sir.
And as you can see, they all came from high courts which had no representation.
Right, sir. Right, sir.
That's it.
Sir, the last question and I think we'll wrap up. The memorandum of procedure has been, like you said, from the Supreme Court side it's final because you signed off on it, you've agreed to it and you've passed it on to the government. Now it's up to them to come back with an answer to finally sign it off and make it official, to put it simply. Do you think perhaps that the government is not signing off on it so it can use it as excuse? When it's convenient for them, they can say it's a memorandum of procedure. When it's not convenient for them, they can say, oh, but the procedure is still in its draft stage. So I don't know, I'm just working out the question, but do you think they're keeping it so that they could use it to their benefit? I can make an observation.
In the sense, it's not good for either the government or the Supreme Court to keep it in such a limbo.
Right, sir.
Saying that for government it's not final, Supreme Court it is final.
Right, sir.
Government said it in the floor of the Parliament.
Right, sir.
And Supreme Court says, no, we have sent it already.
Right, sir.
So it's only one fact. You cannot have 2 facts.
That's true.
Only one fact is true.
That's
so
true.
just sit around, work it out.
That's true.
I've been asking successive Chief Justices to do it.
Right, sir.
And I wish this is cleared at the earliest.
At the earliest, absolutely, sir. Sir, you've mentioned that you're not going to take up any post-retirement job offered by the government at least. Is that immediately, or perhaps you'll change your mind after 2 years or 3 years, or?
Not in any case after 2 years, because I have no idea to. So reason is, since you are from the media also, see, at some point of time, one reason, some point of time, you think that no, the government itself has been saying that after retirement, judges are coming for appointments and yes, with a begging bowl. That was a perception given to. At the same time, all these laws have been made with the tribunals have to be manned by Supreme Court judges also.
Yes,
so on the way you create statute, and on the other side, you humiliate them. That was one reason.
Right, sir.
But I do not mean to say that the judges who have been appointed to tribunals have gone with begging bowls. No, they were asked, their consent were taken. But the people, if the people they want, they will go and after. If they don't want, they will ask them to get as if to be got done out of a charity of the government. That was one impression which I always hated, because having been in a constitutional post where you always held your head high,
Absolutely.
you should not bend it down for your roti chawal. That was not a good thing. And secondly, I thought I can do better service to the nation, which I have taken from the people. I can give back to them better if I'm otherwise serving in the field of law.
So we hope whatever you choose to do, you'll be successful in that, sir. Thank you so much for speaking to us. This is Ritika Jain with The Print.